Okay, so we're now back for part 2 of this, where we'll just continue from where we left off in this opposition to Freedman's motion to strike. Okay, so defamation and privacy causes of action have merits. Defendants devote substantial briefing to the argument that defamation and privacy claims cannot be brought on behalf of a decedent. Okay. In Hill, the California Supreme Court set forth 3 essential elements for a cause of action for invasion of the state constitutional right of privacy. 1. A legally protected privacy interest. 2. A reasonable expectation of privacy. 3. A serious invasion of the privacy interest. Legally protected privacy interests include conducting personal activities without observation, intrusion, or interference as determined by established social norms derived from such sources as the common law and statutory enactment. The second element, whether the plaintiff's expectation of privacy is reasonable, is a mixed question of law and fact. And factors affecting the extent of a privacy interest include advance notice of impending action, customs, societal norms and practices, physical settings surrounding particular activities, and the presence or absence of opportunities for voluntary consent. Likewise, the third element, whether the defendant's invasion of privacy is serious, is a mixed question of law and fact. It is premature to reach these issues of mixed fact and law now on the basis of an anti-SLAPP motion. Conclusion: for the foregoing reasons, plaintiff respectfully requests that the court deny defendant's motion in its entirety. Okay, so here's obviously the proof of service. We've got Exhibit A. So we'll have a look. This is the US Weekly article. And there is the quote there. In the copyright infringement case, I learned what great people Justin and Waiver were. Freedman shared via a statement to US Weekly. I learned that they did absolutely nothing wrong and that there was no liability on their part whatsoever. As a result, the case was resolved without any liability on Justin or Wayfarer or any other defendant's part. This only further confirmed to me that Justin and Wayfarer are exceedingly honourable and highly ethical. I mean, I personally can't see like how this would be damaging to Travis Flores. I don't. Because the case was dismissed, and that was a publicly known thing that it was that he voluntarily dismissed the case. So it's not like it's saying much more, but I can understand, or I can at least appreciate what his widow feels that he has to defend here. Maybe Freedman could have worded it better. I don't think it was done deliberately to basically gain something for Justin Baldoni off off that case or from Travis Flores. Okay. Exhibit B. So this is a settlement agreement and mutual release of claims. This would be interesting. Okay, this settlement agreement and mutual release agreement is made and entered into on this 9th day of March 2022 by and between Travis Flores, individually on the one hand, and Justin Baldoni, Caleb Remington, Wayfarer Entertainment, Lionsgate Entertainment, CBS Films, Kathy Schulman, doing business as Well Entertainment, PW Production Services, and Ambry Genetics Corporation. Each of plaintiff and defendants is referred to herein as a party, and plaintiff and defendants collectively are referred to herein as the parties. So, recitals. Whereas on September 1st, 2021, plaintiff filed an action against certain of the defendants in connection with the creation and development of the motion picture entitled 5 Feet Apart, which plaintiff has alleged was his original idea based on his script entitled 3 Feet Distance. Whereas defendants, including those named and those not named or erroneously named in the action, expressly deny any and all wrongdoing alleged in the action. Whereas on February 28, 2022, Ambry Genetics Corporation filed a motion to dismiss claims 1 and 2 asserted in the action, which remains pending as of the effective date. Whereas the parties have determined it is in their best interest, pursuant to the terms of this agreement, to resolve and settle all disputes, claims, or potential claims and disputes between and among them on the terms set forth below without any admission of liability. Now, therefore, in consideration of the promises herein contained, the sufficiency of which is hereby acknowledged, the parties hereby agree as follows. 1. Full settlement. The purpose of this agreement is to settle fully and completely any and all disputes between the parties. The parties acknowledge that this agreement shall not in any way be construed as an admission by any of the parties as to the merit or lack of merit of the allegations in the action. The parties enter into this agreement to avoid the expense and uncertainty of litigation. Consideration. In consideration of plaintiff dismissing the action, as provided herein, defendants hereby agree to waive any right they may have to seek to recover their fees, costs, or expenses in connection with this action. Plaintiff likewise waives any right he may have to seek to recover his fees, costs, or expenses in connection with this action. No other consideration. The consideration recited and the releases granted in this agreement constitute the sole consideration for this agreement. No representations, promises, or inducements have been made to either party or any of the parties' representatives other than those set forth in this agreement. Dismissal of action. Following the mutual execution of this agreement by the parties, plaintiff shall file a request for dismissal of the action as to all parties and causes of action with prejudice within 3 court days. So it was on the basis of a dismissal with prejudice. There was nothing that Travis Flores could have done later on to have brought the claims back. Notice of withdrawal motion. Within 3 court days following plaintiff's filing of the request for dismissal of the action as to all parties and the court's entry of the same, Ambry Genetics Corporation will file a notice of withdrawal of the motion to dismiss. No assignment of claims. The parties and each of them hereby represent and warrant to each other that they have not assigned, mortgaged, hypothecated, or otherwise transferred any of the claims released by paragraphs 7 to 9 of this agreement. Okay, so release of claims by plaintiff. Except as expressly provided herein, for and in consideration of the terms and provisions of this agreement, plaintiff, together with all entities he owns or controls, and all their respective attorneys, agents, and assigns, immediately, irrevocably, and fully releases and discharges defendants and their respective past and present officers, directors, members, shareholders, corporate affiliates, including without limitation parent companies and subsidiaries, insurers, reinsurers, employees, successors, attorneys, agents, and assigns, or anyone else claiming by and through them, collectively the defendant affiliates, from all claims, liabilities, obligations, demands, damages, causes of action of any nature, and any and all claims, demands, and liabilities whatsoever, known or unknown, suspected or unsuspected, whether at law, by statute, in equity, in contract, or in tort, and whether or not the economic effect of such alleged matters arises or is discovered in the future, which plaintiff ever had, now has, or may claim to have against the defendant affiliates existing from the beginning of time up to the date of this agreement that relate to the action, the original screenplay, or the picture. So I know that probably sounded as much of a mouthful as it felt for me to read it, but that is quite a typical thing. Like, I relinquish you from, and it's not just this claim here. It's like and it's not just the parties as named. It's their entire family history, as found by DNA, and any employees, employers, any attorneys, anyone who you may have met, the person who gives you your morning coffee, and it's not just this claim, it's any claims, whether you know about it or not, whether you suspect it or not, even if you come and find a load of evidence to prove a claim against me, you cannot. I'm releasing you from, I'm discharging any responsibility, so Travis Flores is basically saying, I will never sue you in any kind of, any causes of action of any nature, blah blah blah. So and the one thing I will say, right, just here, yeah, is obviously the release of the claims by plaintiff, right? Part of the claim, I don't know if I can highlight. Can I highlight? I can highlight. Excellent. Now I'm going to have some fun. It also includes the defendant, right? So the wording is discharges defendants and their respective past and present officers, right? It obviously does not include future. So what I've done there is it releases the defendants and their respective past and present, and then it lists a load of categories of people. It does include attorneys, and people will be like, well, surely that gets Freedman off the hook. No, because it does not say future attorney, and he was not and hadn't been at the time Justin Baldoni's attorney. But in case anyone was thinking like that, I like it. It does not, because obviously then, if it did encompass Brian Freedman, if he had previously represented Justin Baldoni, then oh god, then all of this would have actually, I'd be sitting there going, well, hold on a minute, why has this guy brought the claim? Because if this covered Brian Freedman was Justin Baldoni's lawyer in this situation, or for any other matter, to be honest, then this actually would have basically blocked Clemency Uri bringing this action, because it fully releases and discharges defendants and their respective past and present, includes attorneys, from all claims, liabilities, obligations, demands, damages, causes of action of any nature, and any and all claims, demands, liabilities, and so on and so forth. So that basically covers everything, absolutely everything. But Brian Freedman was actually Travis Flores' attorney, and this does not cover any of those people with regards to the plaintiff, who was Travis Flores. However, we then have the release of claims by defendants. Now, well, we'll read it first, actually. Except as expressly provided herein, for and in consideration of the terms and provisions of this agreement, defendants, together with their respective officers, directors, members, shareholders, employees, successors, attorneys, agents, and assigns, or anyone else claiming by and through them, immediately, irrevocably, and fully releases and discharges plaintiff, together with all entities he owns or controls, and all their respective attorneys, agents, and assigns, or anyone else claiming by or through plaintiff or such entities, collectively the plaintiff affiliates, from all claims, liabilities, obligations, demands, damages, causes of action of any nature, and any and all claims, demands, and liabilities whatsoever, known or unknown, suspected or unsuspected, whether at law, by statute, in equity, in contract, or in tort, and whether or not the economic effect of such alleged matters arises or is discovered in the future, which the defendant ever had, now has, or may claim to have against the plaintiff affiliates existing from the beginning of time up to the date of this agreement that relate to the action, the original screenplay, or the picture. So I'm sure people will be thinking, okay, but this bit would cover Freedman. Yes, but only from actions against the defendants in the original case, which would be basically, Justin Baldoni and Wayfarer, which is not the case here. So this is the representative of a deceased former client is suing, the attorney that represented Travis Flores. So this does not actually cover Brian Freedman or his firm. Okay, waiver and final settlement. The parties to this agreement hereby expressly, voluntarily, and knowingly waive, relinquish, and abandon each and every right, protection, and benefit to which they might otherwise be entitled now or at any time hereafter under Section 1542 of the Civil Code of California, which provides as follows. A general release does not extend to claims that the creditor or releasing party does not know or suspect to exist in his or her favor at the time of executing the release, and that, if known by him or her, would have materially affected his or her settlement with the debtor or released party. In making this voluntary express waiver of the protection of Section 1542 of the Civil Code of California, the parties to this agreement acknowledge that they may discover claims or facts in addition to or different from those which they know or believe to exist with respect to the matters mentioned herein. It is their intention to fully and forever settle and release any and all of such matters, claims, and dispute, whether known or unknown, suspected or unsuspected, and anticipated or unanticipated, related to such intention between the parties. This release is and shall remain a full and complete general release, notwithstanding the discovery or existence of any such additional or different claims or facts. Voluntary agreement. The parties expressly warrant that each has been supplied with and has read and has had an opportunity to discuss the terms of this agreement with legal counsel or representatives of their own choosing. The parties further warrant that each fully understands the contents and effect of this document, approves and accepts the terms, conditions, and provisions of this agreement, agreed to be bound thereby, and sign the same of their own free will. So this is what is gonna probably hinder the claim for the estate of Travis Flores, in my opinion, because this part here, the voluntary agreement, right? What it expressly states is that all parties, so that includes Travis Flores. So we've got to put ourselves back in the position of Travis Flores at the time, because he's obviously not here to state his mind, and that is going to be a complicating factor now for Clemenziuri in many ways, because some of the allegations from Clemenziuri is that Freeman didn't adequately represent, gave him bad advice. Well, Travis Flores is not here to confirm that belief, but even if he were, this agreement clearly states that he has had an opportunity to take legal advice, which he has, a legal advice from counsel of his own choosing. Now, he chose Freedman. He took the legal advice. It also stipulates that he has to agree that he understands the contents and effect of this document, approves and accepts the terms, conditions, and provisions of the agreement, and agrees to be bound by it. And he signs this document of his own free will. that is going to be incredibly, it's going to make it very difficult for Clemente to then sort of argue that, well, no, he was given bad advice, he was taken advantage because he was seriously ill. Just because someone is seriously ill, and he absolutely was, he'd had 3 double lung transplants, and he obviously died a couple of years later. He absolutely was, had a very serious condition. That does not mean that they cannot understand or comprehend legal documents, what they're signing, what they're agreeing to. That's not the case at all. This lawsuit was not going for very long at all. It was only going for about 3 months. So if he was compos mentis, enough to initiate a lawsuit, arguably to write a screenplay, and it was not a progressive neurological, illness, and that's what I mean by that. But, he initiated the lawsuit only 3 months before. This lawsuit wasn't dragging on for years. And at that point, he had the, he had the ability to make the decision to initiate the lawsuit. And I do feel like, by the widow saying, well, he was taken advantage of because he was seriously ill, blanket saying, well, yes, someone who has a serious illness cannot think for themselves, cannot make rational decisions. I don't like that, because whilst physically he was very unwell, and I'm sure there was a lot of stress and various things that go with that, but I would not. There was nothing to suggest that Travis Flores could not have made the decisions he made with his own free will. But this clause here, the voluntary agreement clause, is going to be problematic, I think, for Clemente, because that specifically requires Travis Flores to be able to make decisions with who wants to represent him as a legal counsel. He made that decision. It was Brian Freedman. That he consulted with Brian Freedman regarding this document and whether or not to sign it, whether it was in his best interest. And there's absolutely no reason, there's no motive I can see for Brian Freedman giving bad advice just because his client is not well. There is no evidence has been provided here that Freedman goes around giving, shoddy advice to people. What's in it for him? It's more lucrative for lawyers actually to keep a case going. That more money to wrap it up early. As Suri himself said, in the main motion, was, well, pretty much all he did was file a complaint and then he dismissed it as soon as the motion dismissed come in. Well, then that's next to no work. He could have actually fought harder. If this case was meritorious, he could have carried on and his client still would have had to pay the fees. But it also expressly, sort of states that Travis Flores has to understand the contents and the effect of this document, and that he has to expressly approve and accept the terms and conditions and the provisions of it. And but it doesn't just stop there. He has to agree to be bound by it and sign from his own free will. I think this is going to be problematic. In the context of, not for all the entire complaint, but certainly from the aspects where he is saying, well, Freedman did a terrible job and didn't represent him properly and took advantage of him and filed a complaint and then gave him bad advice to withdraw it. That's going to be a problem. So then we go on to non-admission. The parties expressly deny any and all liability or wrongdoing, and the parties agree that nothing in this agreement shall be deemed to represent any concession or admission of such liability or wrongdoing, or any waiver of any defense. So when Freedman said that there was no admission of liability, no evidence, nothing, there was no wrongdoing, there was denials in place, and this kind of cements the fact that, everyone was in agreement that there was nothing about this agreement here which would represent a concession or an admission of any kind. Could he have gone potentially a little bit too far by saying, well, by kind of giving a personal opinion on Justin Baldoni? Potentially, but I'm not sure he was talking about Justin Baldoni, in the context of this original action with Travis Flores. It may be a personal opinion further confirmed to me, because at the time he hadn't spoken to Justin Baldoni. There was no depositions taken, no discovery was started. So I do wonder if it was just bad wording. But when he says, it further told me, well, what did he know about Justin Baldoni beforehand? Who says he knew anything about him? Because there's no evidence that they already knew each other. And actually, the evidence seems to suggest that they didn't. And they didn't get to know each other until, around, after the premiere of It Ends With Us. Because if I remember correctly, it was Jen Abel, I think, or Melissa Nathan, who introduced Justin Baldoni and Wayfair to Brian Freedman. And I think there may be an overlap then in, he might have been reflecting on the man he has come to know now, representing him in It Ends With Us, and then reflecting back to this case. But that's not necessarily commenting on the case. That's just because he can't say that he knows. Really, he knows Justin Baldoni to be honourable just from the representation of the Flores case. Because the case lasted only a couple of months. It was literally a complaint filed, then a motion to dismiss, then this document, done and dusted. They never spoke to each other. So I think the wording was not great. Whether Freedman might have been slightly misquoted, I don't know. I keep an open mind to that. I don't. It's likely that he wasn't, and it was just a bit of a fluster because he was being asked this question, which, he's trying to get balance and get the answer right whilst maintaining client confidentiality on both sides now, because obviously he owes client confidentiality to Justin Baldoni now. But he still has a duty and an obligation to Travis Flores. And I think Freedman was he might have been caught unaware. He almost certainly would have been caught unaware. So it might have flustered him a bit. We've also got to remember the time of this statement as well. This was pretty close in time. Freedman had just lost his home and his law firm. I don't know if he'd lost entirely the law firm, but they were both. He definitely lost his home and his law firm. They was because of the wildfires in California. So it might have been just I think like a knee-jerk reaction to try and give a statement, but word it, and the wording may have just overlapped personal opinion with professional opinion, might have just overlapped a little bit. What else is there? So, advice of counsel. Each party hereby represents that it has read this agreement, has had the provisions fully explained by legal counsel, and is freely and voluntarily signing this agreement upon advice furnished by such parties' legal counsel. The parties agree that each shall bear its own attorney's fees and costs associated with all aspects of this agreement. Okay, so again, each party is this specifically expressly states that each party is representing that they have read the agreement, that they've had the provisions fully explained by their representatives, their legal representatives, and they are freely and voluntarily signing the agreement. So it's another problematic clause. Notices. Any and all notices, demands, or communications required under this agreement shall be in writing and delivered by email and receipted overnight courier to the intended recipient at the addresses set forth in this settlement agreement, or at such other addresses as any party may hereafter designate by notice to the other. All notices shall be deemed given when delivered to the said overnight courier, except notices of change of address, which shall be deemed effective only when they are received. Okay. So those are the addresses of where all of that's going to be sent. Okay, so modification. Any modification to the terms of this agreement must be made in writing and signed by all parties to the agreement. Agreement binding. This agreement shall bind the heirs, personal representatives, successors, and assigns of each party, and inure to the benefit of each party is heirs, successors, and assigns. So this agreement is also binding on Clement Fury, because he's obviously the successor of heir, as he personal representative. He is obviously now the administrator for the estate of Travis Flores. Governing law, jurisdiction, and venue. This agreement is made and entered into in the state of California and shall in all respects be interpreted and enforced in accordance with California law. Any action arising from this agreement shall be subject to the exclusive jurisdiction of the federal and state courts located in the state of California, County of Los Angeles, and the parties each hereby consent to such jurisdiction. Severability. Should any provision of this agreement be declared or be determined by any court to be illegal or invalid, the validity of the remaining parts, terms, or provisions shall not be affected thereby, and said illegal or invalid part, term, or provision shall be automatically conformed to the law if possible, or deemed not to be a part of the agreement if not. Okay, so what that is basically saying is if a part of the agreement is declared by a court or determined by a court to be illegal or invalid, then that will be severed. But that will then, so the remainder of the agreement, the parts that did not have any such declaration invalidating them, will remain in place and enforceable. Over in I'm sure the US has it too, but in law there's a term called joint and several liability, and that's where you can, for instance, in a debt situation, quite often business partners or spouses, they might take out a loan and they don't pay it back, and then the loan provider then wants to pursue legal action to recover their money. They can pursue them both jointly or severally. And what that means is if they both have assets, worth pursuing, traceable, etc., then you can pursue both people or the multiple people. In the event that, say, one person is solvent, earning money, in a position where if you received a court order giving you judgment to enforce a debt, if one of the people was in a position to pay the debt, but the other one, say they were bankrupt, or had no money, no assets, then you could pursue, instead of splitting the debt between the two, you could actually pursue the one person for the entirety of the debt, despite the fact that it was taken out by both people, or, in that case scenario. So that is what, that would be where you could pursue them. You sever and you can pursue one person for the debt of two or more people. So, and that is what we call joint and several liability. And so that it's a similar principle here, where if one or two or more parts of the agreement were deemed to be invalid or illegal, then they would no longer apply, but the rest of it would not. The rest of the agreement would not be affected, and it would still be a valid agreement that would be legally enforceable. Okay, construction of agreement. This agreement is to be construed simply and fairly, and not strictly in favour of or against any of the signing parties. The parties hereto stipulate that any common law or statutory provision that an ambiguous term be construed against the maker of this agreement is hereby waived. This agreement was negotiated jointly by the parties hereto. Okay. So, and that's important, actually, I feel, as well. This agreement was negotiated jointly by the parties hereto. So this is not Brian Freedman has put together this agreement and got everyone to sign it, which is, I thought that from reading what Clement Ciori was writing, I thought that's what had happened. But actually, no, all the parties came together and jointly negotiated this. Okay, counterpart signatures. The parties agree that this agreement may be signed in counterpart. The parties agree that electronic, PDF, or facsimile versions of signatures may be substituted for original signatures. Authority. Each person executing this agreement on behalf of each respective party expressly warrants and represents that he or she is duly authorized. Now it's he or she, not he or it. That he or she is duly authorized to do so in a manner that is fully binding upon such party. Entire agreement. This agreement contains the entire agreement between the parties and constitutes the complete, final, and exclusive embodiment of their agreement with respect to the subject matter hereof. This agreement is executed without reliance upon any promise, warranty, or representation by any party or any representative of any party other than those expressly contained herein. This agreement is contractual and not a mere recital. Any representations or promises not specifically detailed in this document will not be valid or binding on the parties to this agreement. And there, in big capital letters, please read carefully. This settlement agreement and general release includes a release of all known and unknown claims. So you can see they've all got to sign. Oh, there's only one electric signature there. Okay. So that's Randall Jackson on behalf of Ambry Genetics. So this is Justin has signed his, and he's also signed as an owner of Wayfarer. This is Wayfarer Entertainment. Sorry, that was not Randall Jackson for Ambry Genetics. That was for Lionsgate. My bad. Okay, yeah. So Justin is signed as Justin Baldoni, the individual, but also as the owner of Wayfarer Entertainment. Jonathan Strauss, CBS Films. So this is where Travis Flores has signed, along with Caleb Remington. And Tom, I cannot even see that. That is for Ambry Genetics, though. He's the CEO. Kathy Schulman for Well Entertainment. And I could not tell you who that was. PW Production Services Corp. So there we go. That's the entire settlement agreement and mutual release. I will do my next video, I will cover the declarations of both Clement Ciori and Melissa Yeager, who we now know, I did not know before, but we now know was Claire Wineland's mother. I'm curious to see what she says, because I've seen a lot of very positive stories about Justin and Wayfarer from Claire Wineland in her social media posts. There's a lot, and very much, glowing adoration from Justin Baldoni, and not just Justin, Emily as well. So I'm curious to see. I also the end of It Ends With Us, I'm pretty sure that Justin Baldoni, we'll take a note of the people that Blake Lively gave special thanks and mention to. But I'm pretty sure Claire Wineland's dad was one of Justin Baldoni's. It's been quite a while since I've actually looked at the film, so but I'm sure his name's John Wineland. I'll have to go and check. I'm sure I saw someone with the surname Wineland in his list of mentions. And it could well be completely unrelated to Claire, but I will go and have a look, I think. But yeah, I'm going to go through the declarations, because we need to go through all that to get to the Freedman reply brief, which is spicy. We need to do this kind of all in order. So okay, thanks for listening, guys, as always, and it's great to be back.